We are going to start with our second panel, which I am looking forward to. So my name is B, and I'm a professor of law at Case Western Reserve University School of Law. I'm also the associate director of the Law Medicine Center, and to be here to introduce this panel and to also partake of our keynote speaker, which will follow after this panel during lunch. Without further ado, let me briefly introduce our panelists who will then speak, and then we will open it up for any questions. And I'm going to introduce the panel in order that they will speak. So first of all, we have Director Monica Simpson, who is the founder of Charlotte's first Black Gay Pride celebration and Charlotte's African American Giving Circle. She has starred in productions such as For the Love of Harlem, Words the Isms, Walk Like a Man, and so we welcome her here. Going to open up the panel and give us a framework for the rest of the panelists. I'm just giving you brief introductions of all in here. If you want to read more, you can look towards your program. Our next panelist will be Professor Kiera Bridges, who is the author of Reproducing Race, Pregnancy as a Site of Racialization, 2011, published by the University of California Press, and she has her JD and PhD in anthropology from Columbia. She will follow next. Next presenter will be Professor April Cherry. She's a Cleveland Marshall College of Law. She clerked for Chief Judge Judith Rogers, Columbia Court of Appeal. She is a graduate of Vassar University with a BA, and she received her JD from Yale Law School. And Professor Bridges is Associate Professor of Anthropology and Associate Professor of Law at Boston University. And last but not least, we have Attorney Alexa Colby Molinas, who is a staff attorney at the for the Reproductive Freedom Project of U. She is currently the lead counsel in Planned Parenthood v. Strain to the Alabama law that will require all providers obtain admitting privileges at local hospitals, effectively closing clinics in that state. She received her BA from Smith College, her master's degree from Queen's University of Belfast, Northern Ireland, and her JD from Fordham University Law School. Let me welcome up Ms. Monica Simpson.
Yeah. I got it. Yeah, that'll be great. Good morning, everybody.
Good morning.
Oh my goodness, I so feel out of place. I am not a lawyer at all. You know, I would so be a lawyer, but the way that LSAT is set up just ain't gonna work with how I do things. I'm really excited to be here today and to be a part of this event and to share this panel with such amazing really look up to. They do amazing work. So this morning I want to kind of focus in first before we kind of dig deep into all the things we're going to talk about in the panel, and really just set the framework and talk about what the reproductive justice movement is, the evolution of that movement, and why this is a framework that's really taking root today. And we have lots more folks reproductive justice and really reframing the way that they discuss reproductive health rights and, as we say now, justice in this country. But to also give a little more feedback as to how I got to this role, because I'm definitely an artist first. I've always been an artist, and that's of my work, and I do believe in the concept of artivism, as I call it, right? Artistry and activism connecting together, because I really do believe that artistry is the heartbeat of our movements and really helps to move our work forward. But what really got me into this role and this leadership role in Sister Song, I am a Southern-based, grown, Black woman, Carolina, and my activist journey started in North Carolina, and it was really centered around LGBT And then it kind of shifted into looking at the prison industrial complex. And my work was really on abolishing for-profit private prisons and immigrant detention centers. And while I was doing this work on LGBTQ equality, on the prison industrial complex, I felt like at every movement that I stepped into, at some point, I had to kind of check some part of my identity at the door. If I was doing work around LGBTQ equality, they weren't really talking about the fact that I was a Black woman, right? And when I was doing work in the PIC, they weren't really interested in the over-criminalization and over-policing of LGBTQ folks in this country and how that definitely intersected with the work that we were doing. And then in 2007, I had an opportunity. And also while I was doing that work on abolishing for-profit prisons and immigrant detention centers, I had the opportunity of working in these border states and seeing mothers behind bars with babies, right? Like their children also wearing, numbers, right? This was insane. And I was like, this is bigger than just like the prison industrial complex, just criminal justice issues, right? It's something bigger. And so in 2007, I had the opportunity of going to the United States Social Forum. And it was there introduced to the reproductive justice framework. And I got a chance to hear Loretta Ross, who was my predecessor and one of the founders of Sister Song and one of the creators of the reproductive term. I got a chance to hear her speak about this more intersectional framework. And it was the first time I had the opportunity to really hear the term intersectionality and what that meant. And what she told us, and she quoted Audre Lorde at the time, that no one person lives a single issue life, right? Whenever we're making decisions, it's around our reproductive and sexual lives, whether it's around economic issues, whatever that is, multiple identities come at play, right? And we can't separate those things from one another. And so when looking at sexual and reproductive health, we can't just focus on like this one singular issue, which the reproductive health and rights movement has really been working on for a very long time, which is to secure the right to healthy and safe abortions, right? That is incredible work, and we continue to do every single day. But in 1994, 20 years ago, Black women came back from like being a part of like these international conversations and working with women all across the world on how they were lifting up issues in their own countries and communities. And they came back to the States and said that we need to be talking about our issues here in the like other women are talking about their issues across the country. How can we bring this learning back? How can we start to move this forward? And so that's when they created the term justice. It was 12 Black women who sat in a room together, and they said, it's not just about our reproductive lives, reproductive rights. It's also about how other social justice issues impact our lives. And that's how they came up with reproductive justice. And so this was also at the time of the height of the health the Clinton administration, right? And so all these conversations were starting, and everyone was really getting this buzz going around about like healthcare reform. And so these women were like, yeah, that's great. We need to be talking about healthcare reform. We also need to make sure that in this larger conversation that we're not losing the discussion around reproductive health, right? And we need to make sure that the most vulnerable, the most marginalized communities are centered in nations. And if we're doing that and the exclusion of that, then we do not have. And so they really started to move and operate with this framework of reproductive justice that was rooted in the human rights framework, that incorporated this notion of intersectionality to really achieve, reproductive justice. And so one of the things that they really worked towards dismantling, because this is not just clear with folks in the room, because I know reproductive justice is relatively new and folks are excited about it. It's not a synonym for reproductive health or reproductive rights, right? It's not something that you can just put in the place of, right? Justice is its own movement, its own framework that really is about dismantling systems. That is at its core, right? It's about dismantling the system of white supremacy. It's about talking about how these communities have a voice, have an expertise, have a need to be centralized in ways that they never have been before. That is like at the root of the reproductive justice framework. And so if there are organizations who are using and they're not working to do those things, then they're not doing reproductive justice. Okay, clear about that. And we're also very unapologetic about the fact that this movement was created and is led by women of color, that. It's about shifting the narrative, shifting the dynamics, right? Again, and moving the most marginalized to the center. So the other thing that reproductive justice lifts up, right, is this notion of reproductive oppression, is what we call it, right? And this is like the control, right, of our sexuality, our bodies, our labor, right? And so in the way that we go about doing this work, it really is about addressing what arching kind of examples of reproductive oppression are. Again, not just looking at this from a single issue lens, but how reproductive oppression kind of expands beyond just restricting the rights to abortion, right? If you're also criminalizing and over-criminalizing mothers, if you are also, which we are seeing a lot in this country today, right? I know that we're all watching the news and we're paying attention to this. We just had Purvi Patel looking at facing 20 years in jail. Right before her, Sister Song closely with the Marissa Alexander case, right? Another mother being overly criminalized for trying to protect herself and her family, right? And the list goes on and on and on. Like, we keep seeing these things pop up in Tennessee, the pregnancy criminalization bill, right? Coming up, and these are all examples of reproductive oppression. And in all of these ways, we centralize race, right? Because we see that is like the root to these issues that we're seeing popping up these days, and how we just don't like it. So we're working very hard to dismantle that. There's no other like really articulate, cool way to say that we just don't like it, right? So we don't. So yeah, so those are the main like pieces, and I have to pull back up my notes now because I was like going on a tangent, as I normally do. An artist, you just kind of get wrapped up in what you have to say. But I do want to back before I circle back. So the other thing that we have been very focused on as a matter of like reproductive oppression, but also like where we're seeing this intersection of reproduction and race, right? Like, is the rising rates of maternal mortality in this country. So last year, Sister Song worked with rights, yay for them, to do a report called Reproductive Injustice. And we looked at gender and racial discrimination in the U.S. healthcare system, right? Again, really intersection comes at play, and the impact that has on on the communities that we serve. And so we had an opportunity at Sister Song to sit down with women in Georgia and in Mississippi, because Georgia is the state with the highest maternal mortality rates in this country, right? Black women in the South are dying at a rate 4 times higher than white women in this country. That is a major injustice. And so what we had to look at was why that was happening, right? Why are Black women dying more? And this wasn't even necessarily focused on economics, right? Because we were looking at the fact that even if a woman had access, she had, a decent income, or she had a livable wage, right? And we can all around what that really looks like. But had, a pretty firm, like, economic kind of rooting, she was dying at a rate 4 times higher than white women. Like, what is that really about? And so we sat down with women all across the South, in these 2 states in particular, because we really wanted to focus in on the most marginalized states. And, I've been doing this work. I've been an activist for almost over 20 years now, right? And I think that I've talked to all kinds of people in all kinds of communities. So I think I've heard a lot of different stories, right, about what injustice looks like and what oppression looks like in communities. But when I sat down with these women in Mississippi, my eyes, I could not close my mouth with some of the stories that I heard from women and their and how they deal with the healthcare system. We heard stories about women that went in, they were automatically shamed or assumed, or the practitioner assumed that they did not have any money, they did not have any health insurance, like immediately walking into the door, discriminated against, just because of the color. Did not matter about what they were coming in with, what their knowledge was, anything. Just for them walking in the door and looking for either to talk about family planning, or to talk about the pregnancy that they had just found out about, or to what's going to happen after they have the baby, immediately not being shame for their decisions. Even one woman told us that, yeah, the doctor told me, well, I'll see you again in a couple of weeks because you'll probably be pregnant again after she, right? Incredible, like just insane. And it's so sad and it's scary to think that these things are really in our healthcare system as it pertains to our sexual and reproductive lives and health, right? And so from this report, we were able to address some of the barriers that really made it impossible for folks to get the best care for themselves and for their families. And the first thing was really around the fact of access, right? So access is huge for communities of color when we talk about this intersection of race and our reproductive lives. Access. In the South, folks did not have access. And in the South, we're not trying to expand Medicaid, right? And so, like in Georgia alone, if we were to expand Medicaid, 600,000 people, more thousand, right, would have access to health care. And our governor's not willing to do it. And we're seeing that we're seeing that across the South overwhelmingly, right? We also talked about economics, right? Because as we know, people of color, women of color, Black women in particular in this country continue to fall further and further down on the economic scale, right? And so when we talk about this wage gap and the fact that folks don't have need to be able, the resources that they need to be able to get the services that they need, that's a huge barrier for folks to be able to have a healthy life, right? A healthy reproductive family and all of that. And then the other piece was around the fact that discrimination is still alive and well. Racial discrimination in this country. I know there are some folks who feel like, you know, it doesn't exist anymore. I know my brother Common was like, if we just extend a hand, right? I know that these conversations are happening, but unfortunately, the way that it shows up in our communities isn't that simple. It's not that just kumbaya. It's still a huge issue, and it's still a barrier for folks to be able to receive the care that they need. And so we were able to take this report in Geneva before the Committee on the Elimination of Racial Discrimination. And y'all, the response that we got from these world, they were like, what do you mean they're not expanding Medicaid? Why isn't Medicaid just universal? Like, I mean, these are world leaders asking us these questions. We're like, we're with you. How about you tell? So there was that piece. And then, but they accepted all and really came down hard on our leaders. Like, what do you mean that this is still happening in the United States? Claim to be like all great, right? And it's not, right? So we were very, very proud of that. And that's actually the other good piece of that is that we're also going to be presenting this before the Women of the World Summit in New York next week. So this is making this international connection. And this is one of those issues, and this is why reproductive justice is so important, because our lead into conversations around reproductive health and our sexual and reproductive lives is not just centered on abortion. It's not just looking at it from the choice angle that really alienated and excluded a lot of folks from the conversation, especially when we're talking about communities of color, where choice is always an option, right? So that's the context about reproductive justice, and I'm really excited to be able to hear more from the panelists and for us to engage in dialogue with each other after we get through with that. So I think that I hit my time. Did I do pretty good? That's what's up. I look forward to hearing from y'all once we get up there. It is. But your shoes are amazing.
Thank you.
Yeah.
So I am so very excited to be here. Pardon my voice. I lost my voice about 2 days ago. Been yelling at 1Ls all week. But I think I have enough of it to get through my talk today. So today I will present some arguments from a book that I've been writing. The name of the book is The Poverty of Privacy Rights. And essentially the punchline of the book is that poor mothers don't have most people who have examined poor mothers' experiences with the state agree that they don't enjoy privacy in any real sense of the word. The state is all around them. It's in their decision-making processes about whether or not to have a It's monitoring them as they parent their children. It's collecting the most intimate data about them. It's everywhere, right? So in light of the fact that the state is all around, and in light of the fact that poor mothers cannot keep the state out of their lives in the same way that wealthier mothers can, most scholars who have examined their experiences have or have argued that they have privacy rights, but their privacy rights are weak or they're meaningless. These rights are constantly violated. And so what I'm seeking to do in this book is to shift the discourse. I'm disputing that poor mothers have privacy rights that are weak or meaningless or constantly violated. Instead, I'm arguing that poor mothers do not have privacy rights at all. They've disenfranchised of their privacy rights. And so this book argues that poor mothers have been disenfranchised of privacy rights in 4 dimensions. Spatial privacy, that's the right to keep the government out of your physical home. Informational privacy, that's the right to keep personal and to prevent it from being aggregated and disseminated. Family privacy, that's the right to make decisions about how one will raise one's child. And reproductive privacy, that's the right to make decisions about whether or not one will have a child. And so the book argues that the reason why poor mothers have been disenfranchised of privacy rights in these 4 dimensions largely accepted among people with power in this country. Poverty is a direct result of individual bad behavior. Specifically, people in power believe that poverty is caused by individuals' bad moral character. And so because poor mothers are thought to have a bad moral character, as evidenced by the fact that they are poor and now they're pregnant, and because their bad moral character necessarily implicates children as far as they're pregnant or parenting, they're not giving any privacy rights that could that the state uses with and against them. So, there are 2 ways one can frame this argument. One can say, when I say, poor rights, it's like a rhetorical flourish. It's kind of like you have a feather boa and you're throwing it across your shoulders, like they have no rights. It is, and that's kind of like assuming that they have rights, but, I'm just going to say they have no rights in order to like make my point. A second formulation is the analytical argument. It claims that being presumed to be of good moral character is analytically a precondition for privacy rights. And because poor mothers are not presumed to be of good moral character, they are not given any privacy rights analytically. And so I'm making analytical. I'm not making the feather boa argument. I'm making the second argument. And why? Why am I making the more controversial, more difficult argument? A lot of reasons, but most importantly, I'm making the analytical argument because it allows us to draw parallels between poor mothers and other groups who have been disqualified from having rights, like Black people in antebellum America and post-Reconstruction. Right? Speaking about poor mothers as analogously not having a set of rights allows us to see continuities between these groups and other groups who have been formally disqualified from having rights, and also informally disqualified from having rights. And seeing those parallels allows us to think about the and perhaps it allows us to imagine different solutions. And just to elaborate on that point, if it's not about giving rights teeth, but rather giving rights instance, we might be well advised to look to other historical moments for instruction. What did it take for other disenfranchised groups to win rights? If history is a teacher, then the answer is not about changing the law or giving more, but rather it's about undoing the cultural work that has attached immorality to the fact of poverty. So there are those who will disagree with me unwisely. They'll disagree with me, and they'll say, poor mothers have privacy. The government has this interest in protecting children, and that government in protecting children from abuse and neglect sort of over privacy rights. And so, the reason why it appears that, poor mothers don't have privacy rights is because the government is just protecting children and is overriding their privacy rights legitimately. So, in response to that, we have to ask, specifically, I study Medicaid, and, specifically natal care programs, which require poor women to basically expose themselves completely to state surveillance. We have to ask, why does the state presume that poor pregnant women and poor mothers are at risk of using or neglecting their children? And so that unwise person who disagrees with me will say, well, a mother's poverty sort of yields the possibility to be able to meet the material needs of her kid. All the state is doing is making sure that she's going to meet the material needs of her kid. But the court has States to enter poor women's homes just to make sure that they're not lying about their eligibility for public benefits. That has nothing to do about protecting children. That's just like, do you really need Medicaid? Do you really need, cash assistance? The court has authorized states to ask questions that go beyond any inquiry about whether you can actually meet the material needs of your kid. The court has authorized states to coerce women to avoid motherhood, family caps, right? It's like, you're not getting any more money, don't have any more kids, right? That has nothing to do with meeting the material needs of existing children. Furthermore, the court has authorized states to coerce women into motherhood, upholding prohibitions on the Medicaid spending on abortions. Right? So state surveillance goes way beyond ensuring that poor mothers are able to meet the basic needs of their kid. Instead, it amounts to a blanket surveillance of poor mothers. So it's worth noting early and often that wealthier women engage in the same behaviors that poor women engage in, right? Wealthier women cohabit with men they're not married to. Wealthier women have colorful sexual histories. Wealthier women smoke cigarettes and drink alcohol while pregnant. Wealthier women use illicit drugs. They miss prenatal care appointments. They have histories of sexual and intimate violence. They have unplanned pregnancies, et cetera, et cetera. But no state has erected an elaborate bureaucratic tool with which it can take an accounting of every non-poor pregnant woman. And the point of the book is to say, if a state managed to do that, to erect an elaborate bureaucratic tool with which it can take an accounting of wealthier women, that tool will be struck down as a violation of non-poor women's privacy rights. Now, telling that no state has erected this extravagant bureaucratic tool, it suggests that the state is not really interested in protecting children from abuse. Instead, it is only interested in protecting some children from abuse and neglect. That is, the state assumes that only some children need to be protected from their mother. Those children are the ones that are women. Why does the state make this assumption about poor women? Because poor women are poor, and because we explain poverty in this country of individual immoral behavior. So I am sitting on a panel about race and reproduction, and that raises the question, how is everything, how is race implicated in everything that I've been saying? Well, when society presupposes that poor mothers have bad moral character, and when the law denies them privacy for that reason, it creates a very disturbing equality problem. It produces is one in which wealthier women have privacy rights and poor counterparts have nothing. Now, those of us interested in racial justice will find this deeply disturbing, and that's because the undeniable truth is that race and class follow each other closely in this country. Race is disproportionately represented among the poor. So it follows then that racial minorities are disproportionately represented among those who have been denied privacy rights. This means that wealthier folks with privacy rights are disproportionately white, and the poorer folks without privacy rights are disproportionately racial minorities, and that's not cool. If we're interested in racial justice, though. Now, critical thinkers about race will also pay attention to the way that racial discourses have functioned to produce this legal landscape where wealthier women have privacy rights and poor mothers don't have privacy rights. So we can only construct all poor mothers as sort of presumptively, immoral, and have a presumptive bad moral character if we reject structural explanations of poverty, right? Structural explanations of poverty say that, it's the macro structures in which individuals exist that cause poverty, right? So structural explanations of poverty, poverty is caused by things largely outside the control of individuals, like economies that contract, or industries that are moved overseas or disappear entirely, or our choice to criminalize property crimes. Or mass incarceration, or the devaluation of women's labor, or implicit and explicit racial bias, and or the financing of the way we choose to finance our public schools, the way we choose to implement our immigration policy, undocumented populations, deportable and therefore easily exploitable. And so individual explanations of poverty, on the other hand, say, we don't care about the structures. Poverty is actually caused by, personal failings of individuals. The issue is that those individual explanations of poverty, consistently have had a lot of traction in the U.S., right? Meaning that a lot of people believe in individual explanations of poverty and reject structural explanations of poverty. Now, if we put that fact, that a lot of people believe in individual explanations of poverty, that fact into conversation with the fact that racial minorities have always been disproportionately represented among the poor, then we possible explanation for why large numbers of people in the U.S. have believed poverty is caused by individuals' moral deficiencies. It is easy to moralize poverty when those who are impoverished are racial others. And it is especially easy to moralize poverty Black people, who are the group that are most disproportionately represented among the poor, and when they are the most represented among the poor, and when the racist discourses that describe Black people describe them as lazy, as sexually immoral, as labor averse people, right? Which is to say, race plays an important role in explaining how we have arrived at a present where substantial numbers of people poverty in terms of individual personal shortcomings. And race plays an important role why the country has been comfortable with denying privacy rights on the basis of the presumed bad moral character of the rights bearer, right? And the argument that, the foremother of all legal studies into race and reproduction, Dorothy Roberts, has made in her scholarship, and she's made this claim quite forcefully. She said the state has always mothers, whether married or single, to need public supervision and not to be entitled to privacy. And she said the state is more willing to intrude upon the autonomy of Black women. She's made the claim very forcefully. A little bit of gloss to her claim, and so so she might be accused of a racism in the way that it existed in the 1960s. Like explicit demonstrations of racism, like people are saying, no, we're going to deny privacy rights because you're want Black people to have privacy rights. Instead, I'm describing a racism that is more oblique. I'm saying that cultural discourses that have existed since Black people first set foot in this country have described Black folks as lazy, as promiscuous, as unintelligent, and when they comprise the poor, or when the poor are fortunately Black, then it's consistent with existing cultural discourses to suppose that the poor are poor because they lack good moral. And so race explains why we in this country think that that this is a politically acceptable state of affairs. And in my last 2 minutes, I want to address an argument that we hear often. The argument is that, the poor mothers have privacy rights, but the problem is that they just exchange those rights for government benefits, right? So they have them but then when they go to the state in order to get prenatal care, or they go to the state in order to get cash assistance, they have to trade those rights for benefit. And the court hasn't even, prevented states from requiring the exchange. There's a unconstitutional conditions doctrine that the court could use to stop states from requiring women to exchange their fundamental rights. The court hasn't used it. But most important about this argument is that it presupposes that poor women have rights in the first instance and that they have to give them up. I reject that argument. I reject that argument because it requires us to narrow our focus when poor women turn to the state for assistance. It requires us to, it encourages us to divorce poor mothers from the context they live their lives. It discourages us from looking at their lives prior to the moment that they seek help. But if we properly contextualize poor mothers, we see that they don't enjoy privacy even when they do not receive a welfare benefit, right? Their lack of privacy is not a result of their seeking government assistance. Their lack of function of their poverty. And so think about what would happen if poor mothers were to say, okay, I'm not gonna give my privacy rights in exchange for this food stamps or this, WIC. I'm gonna keep my privacy because if I receive food stamps, then I'm gonna be required to give them away. Poor mothers wouldn't be able to feed their children. When children are malnourished, the state considers that a justification for involving child protective services and families. And when CPS is involved in a family's life, there's no privacy. In fact, you might have your parental rights terminated. Think about what would happen if poor mothers refused to exchange their ostensible privacy rights for public housing. They're like, I'm not going to give my privacy rights in exchange for this benefit, this public housing. They have two options. They would likely have to live with a friend or family member, right, temporarily in non-ideal, overcrowded situations, or they might be homeless, right? There's a parent's inability to provide safe, secure, long-term housing as a justification for CPS in a family's life. And again, CPS means no privacy. Think about what would happen if a poor mother just either declined to exchange her ostensible privacy rights for cash assistance from benefits from TANF. She would be unable to feed and clothe her kid. Again, another justification for involving the state, for involving child protective services in a family's life. Think about what would happen if poor mothers decided not to exchange their privacy for Medicaid benefits. Oh no, I'm not going to use this, going to exchange my privacy for the care that you're offering me. That would mean that she would be unable to get prenatal care. Again, yet another justification for involving of services in a family's life, right? So in conclusion, poor mothers are damned if they do, they're damned if they don't. They lack privacy if they accept benefits, and they lack privacy if they don't accept benefits. And that leads me to conclude that poor women, poor mothers don't have privacy rights at all. And I'll end there. Thank you.
Voila. By the way, if you want to use this clicker, you can. Which one is yours? Where's
That one.
Okay.
I don't know how to use the clicker.
Okay, you can just. Yeah, that's fine.
Okay, great. Right. Good afternoon. It's already afternoon. I too am excited to be here. My name is April Cherry. I teach at Cleveland State University down the street. And for the last 10, 15 years, I've mostly been thinking about and talking about of pregnancy, ways in which the state controls the pregnancy of poor women and women of color. Today, I'm sort of switching my focus a little bit, and I'm talking about infertility. You see that my talk is labeled Race, Infertility, and Reproductive Justice. But even though I've labeled my talk that, I'm not really talking about infertility, because infertility is a term of pretty limiting. That infertility, at least the way demographers use it, means that who is married or cohabitating with a man, having regular unprotected sex, isn't able to conceive within a year of having unprotected sex. So it leaves a lot of people out. So I'm really talking about sort of a broader category of people I refer to as involuntarily childless instead. And so that includes both women who are fertile, but also women who are not cohabitating, but having sex and able to get pregnant. It also includes women who are able but aren't able to sustain the pregnancy, right? Can't carry the pregnancy to term. So I'm going to talk about these women and sort of how we approach the problem of infertility or involuntary childlessness. And these are sort of things I'm going to try to talk about different racial, ethnic, how infertility affects different racial, ethnic groups, what factors might lead to these differences among populations, and then talk about sort of how we have thought to, which hasn't been very well, and how we might sort of think about other solutions. And so talk a little bit about the difference between distributive justice solutions, reproductive justice solutions. So I've already told you about what infertility means. What I haven't told you about is that infertility and this other thing, impaired fecundity, sort of the more broad group of people, it's experienced by a lot of people. The latest figures we're told that about 6% of women in the United States experience infertility, and that amounts to about 1.5 million women. When we talk about impaired fecundity, which is that other group of women who are habitating with men, but still are having sex, and then we look at a longer period of time, 3 years, but are unable to conceive within 3 years, or a pregnancy to term, we see that that's a much larger group of women. That's 11% of women, which amounts to about 6.7 million women in the United States. So again, I'm really with this sort of broader number, because when we add these numbers together, we get, what was that, 8 point something million women in the United States that experience infertility. And infertility is important because, for two reasons. One is sort of the cultural meaning of motherhood, right? That capture, I think, or at least think about the experience of involuntary childlessness in a culture where women who are not experience a lot of shame, a lot of social stigma, even ostracism sometimes. And then we want to also capture sort of the grief of women who want to mother, are unable to carry a pregnancy to term, in a culture where genetic tie is important. And I think we probably all know women in either of or both of those categories. So I've given you a sense of the numbers. So 8 point something million women who experience involuntary childlessness. Interesting that the of involuntary childlessness differ upon race. We're not surprised about that, right? We know that race and class matter. We live in a culture where accords some of us access to resources and some of us not access to. So what do the numbers tell us? The numbers tell us that about almost 20% of women, black women, experience this impaired fecundity. 18.2% of and 6.9% of white women. This disparity in despair, we can describe this as a disparity in despair, that women of color, racial ethnic women, experience a larger disparity and despair. And perhaps that's something we should do something about. Mm-hmm. So what are we doing? I'm really bad with slides. My research assistant I'm really trying it out. It's not working so well. But, so what do we do about it? What do we do about this sort of really large social problem? Well, by and large, we've done nothing. Or maybe that's sort of the boa flourish. Something. We've done, the CDC did launch a infertility prevention project, and sort of attached to sort of STD prevention. But I think that ended in 2013. So we don't really, wasn't very successful, given that the rate of infertility and impaired fecundity has remained stable for 2 decades. So the CDC maybe tried, but didn't try hard enough. But I think our overwhelming response to infertility has been to construct infertility as solely an individual problem, and solely as an individual medical problem, rather than a public health or a social justice problem. So because we've described it as an individual problem, and because we've described it as a medical problem, we've sought to implement a medical solution. And in this world of technology, the medical solution that we have chosen has been a default to assisted reproductive technologies like IVS and ICSI and all of those fancy things, but things like IVF, right, in vitro fertilization, and other forms of reproductive technology. We have decided reproductive technology is going to solve our infertility problem. Well, has it? No, my slide. I don't have a slide for that. Has it? No. Well, how do we know it hasn't solved our problem? Okay, so we know that that out of the 8.2 women that experience some sort of involuntary childlessness that we think are due, the CDC tells us that 7.4 million women have received some form of infertility services. Now, 8 point something having impaired fertility, and 7.4 million receiving some form of. That makes it look like we're doing a good job, right? That makes me think that most of the women for whom motherhood is important get access to some sort of services. But then when you sort of look at that more closely and look at what the CDC means by infertility services, wait, medical tests, okay, so infertility services are defined as including medical tests to diagnose infertility, medical advice about infertility, and treatments to help a woman become pregnant, services other than routine prenatal care to prevent miscarriage. So if you go to the doctor and get some advice about infertility, you are counted in that 7.4 million percent of women who receive infertility services. So the numbers made me feel good at first, but then maybe not so much. Because what the numbers tell us is that the numbers are misleading, right? They're misleading because what infertility services mean, but they're also misleading because they don't tell us who actually gets services, who actually gets any of those. And I think Michelle has sort of talked about this in some of her work, that when we rely on numbers like who's getting medical services, right? The number of women who get medical services, bunch of people who don't have access to medical services, right? And so if we rely on that number to sort of think about how well we're servicing women who need medical services, it's not that helpful, right? Because it doesn't include the number of women for whom childlessness is a problem, but can't afford to see a physician. And then when we think about race, we know that Black and brown women, racial ethnic women, are unrepresented or unaccounted for in those numbers, right? So they tend not to be included in those numbers about who gets services. I don't know. So then now I'm on to causes of infertility. There are maybe 4 or 5, I have A through E, so is that 5? 5 categories of sort of general categories of what, oh man, there's 5 minutes left. Female infertility, age and delay, preventable medical, and other medical factors. I actually really sort of want to highlight this. So I won't get to talk about reproductive justice, but that's okay because Monica's already done that. Age and delay. This is the one that I think this is the problem that we sort of focus on because this is all about reproductive technologies and it's all about white women. Fertility declines with age. White women who are educated, wealthier women who are delaying motherhood careers suffer from infertility because they wait too long. We know that infertility drops precipitously after 30. They say 35, but it's really 30. And so we start working on solutions. And our solutions are all about technology. Companies offering money for egg freezing, not restructuring the workplace, right? That's off the table. Egg freezing on the table. The cause of infertility for racial ethnic women and poor women is highly preventable. And this is the thing that we're really not doing anything about. The highly preventable causes are pelvic inflammatory disease. And pelvic inflammatory disease is often a result of untreated sexually transmitted diseases. Studies show that tubular damage, so damage in the fallopian tubes, occurs after pelvic inflammatory disease. So 12% of the women that have one bout of pelvic inflammatory disease have tubal damage. If a woman has 2 bouts of pelvic inflammatory disease, she has a 40% chance of having tubal damage. And if she's had bouts of pelvic inflammatory disease, she has an 80% chance of tubal damage. And pelvic inflammatory disease and this tubal blockage can happen even if the STD has been treated. I mean, it really is a problem with chlamydia and gonorrhea. I mean, we knew there were problems already. Now we know that there are bigger problems. The other things I want to sort of point out are these lifestyle factors. Also, maybe preventable, maybe manageable, but maybe something we should be focused on instead of technology. These are sort of lower tech solutions. Diabetes, polycystic ovarian syndrome, uterine fibroids, anemia, poor general health, including poor nutrition, obesity, Lord knows, it's hard to be a Black woman in this society, right? These are factors overwhelmingly affect or disparately affect women of color than over white women. Lifestyle factors, I didn't know what else to call it. Environmental pollutants. Women of color and their significant others are likely to work in conditions where there is environmental pollutants that cause a decrease in fertility. 3 minutes left. Okay, I'm talking really fast. One of the reasons why I think we sort of don't focus on the causes of infertility that are for Black women or Black and brown women, because infertility has been constructed as a problem about white women. Actually, yesterday in the barbershop, half the time my hair is looking erect. Because yesterday, I was in the barbershop, and the barber, they were talking about Black women, and he said, we don't die, we multiply, right? There is this myth of Black hyperfertility. And on the other hand, so that makes infertility not a problem are supposed to have, so there's more shame, but it's a problem of white women. And so I went on the internet last night after dinner thinking, oh, I gotta do a PowerPoint, and I looked up infertility, pressed images, and I came up with all white people, right? You know, so it's either some cartoony white people, some white women giving themselves fertility drug shots, you know, stressing over, I think that is a pregnancy test that is a negative, the woman there. And then that's a white couple talking to their physician. So if infertility is a problem and not a problem for Black and brown women, then we don't even have to address the problems of infertility of Black and brown women because they don't matter. So what we end up is with what lots of social sciences have called is a system of reproduction. A system in which some people are empowered to reproduce while other people are disempowered. And of course, this falls on racial grounds. White women and white couples are empowered to reproduce, and Black people are disempowered. The one thing I want to do, because I have just a minute, is talk about why distributive justice doesn't work. So one way, when we talk about infertility, there's been some suggestions that a way to solve this problem, unequal access, is more access, right? Increasing access to technologies by requiring insurance mandates, requiring insurance companies to cover the costs, right? And so that would open it up, I think, to some people who otherwise couldn't afford it. There's been about expanding family planning dollars, right? Title 10, isn't it Title 10 family planning clinics, which poor people frequent, right? They are focused on not having children, right? Contraception, right? That's what family planning is. Well, what if we sort of throw some more dollars there and make them also deal with issues of infertility? Give them money to do ART. Well, that's a problem. This idea that ART is a solution to infertility makes lots of assumptions that I don't think we should make. It assumes that ARTs are successful. It assumes that there's no harm to the resulting children. It gives way too much primacy to the genetic tie, I think Jennifer talked a little bit about. And it suggests, again, that infertility is an individual problem, not a social problem. ART is a technical fix. ART isn't as successful as we're led to believe. Overall, 30 to 35%, depending on who you talk to, 30 to 35% of the women that participate in ART walk out of the hospital with a baby. Depends on how old you are, really. When you get to be 40, so maybe that's supposed to be YO. When you get to be 40, so maybe that's after for professional a partner or something, or you've gotten tenure. The chances of you walking out of the hospital with a baby are really small. And when we talk about infertility fixes, that's really what we care about, right? We care about whether or not people are getting pregnant, but we also care about whether the children that they have, the children that they have are healthy. And there's some suggestions that maybe those children have problems like the ones listed there. So in closing, I think we need to sort of shift our attention from issues of distributive justice and think about what solutions we might come up just on reproductive justice instead. Thank you.
Be careful.
Yeah.
Is that where you have your notes?
Yeah, yeah.
Okay.
Maybe I can't.
No, I think you can. I just not sure how to do it.
Oh, I just saw it. All of
Where'd
a
you see
sudden.
it?
Wait. No, not there. In the PowerPoint thing.
Where is that?
Go into the program.
Okay.
There was a little button.
This. Yeah, but you want your notes? Reading view?
Yeah, no, we're looking for presenter view.
Sorry.
Thank you. No, it doesn't. Here, hold on. Presenter
Oh, there
view.
you go. You got it.
Can't do it.
No.
It's all right. Forget it.
Do you just want to get it? Wow.
I'll just do it from the beginning.
Are you sure?
Yeah, it's fine. Sorry about that. So I feel a little self-conscious because I am the first, I think, litigant bar to talk. So I'm not an academic. I'm not an artist. So my presentation is going to talk a lot about the law. But that's what I do. So I'm here to talk about a case. I'm a lawyer at the ACLU, and I'm talking about a case that we brought to challenge Arizona's ban on and sex selection abortions. And I should acknowledge that I have two amici in the audience. Professor Borgman and Professor Burns are both amici in our case as well. But so this is a challenge we brought to this law on behalf of the NAACP of Maricopa County and the National Asian Pacific American Women's Forum, which is a group of Asian American, Asian Pacific Islander women, on a chapter, arguing that Arizona's law violates the Equal Protection Clause under discrimination theory. We didn't bring a privacy theory, a race discrimination theory. And we allege that the law was passed with a discriminatory purpose to monitor and scrutinize the reproductive decisions of women of color. The case is currently at the Ninth Circuit, and specifically we're really only now addressing the issue of standing. And the specific question before the Ninth Circuit now is racial stereotyping and stigmatization in and of itself sufficient to confer Article 3 standing, right, to confer injury sufficient to allow you to go to federal court? Or do you also have to show some other harm in addition to stigmatization? So do you have to, here, what they're really thinking about is, do you have to show that you prevented a woman from having an abortion because of her race to bring a race discrimination claim? Or is the stigmatization enough? Now, I think this is an interesting question, in and of itself. I think it's just as a matter of standing. But, in the abortion context, and, if we're here about the rhetoric of reproduction, and specifically on this panel, right, racialized rhetoric of reproduction, I think it invites us, reproductive rights, reproductive justice advocates, to have a broader understanding of what we think of as harm, right, in terms of the right to abortion or reproductive rights in general. And specifically, right, is there a legal response to laws that, perpetuate and enshrine stereotypes about the reproductive decisions of women of color, right? Is there, I know obviously we can critique it up and down, but is there a legal response? Can we go to court? So first, though, I do want to put a little bit in context, right, that, in the past few years, many abortion restrictions have been enacted. And I think you can see from this in 2011 and 2013, right, more were passed than just in the previous decade. And most of these laws do burden access, right? Most of these laws do make it either more difficult or just impossible for women to access abortion. But not all of them, right? A lot of these laws are passed, I don't know if that's big enough. A lot of these laws are passed, right, really with the sole purpose, but to shame women who have abortions. So this is just a Doonesbury comic strip. This is forced ultrasound law, right? So that's a law, right, that requires women to undergo an ultrasound abortion, and they have to screen in front of their face, so they have to look at it, and the doctor is required to describe certain things that are seen on the screen. The woman is permitted to avert her eyes and plug her ears and go like, nah, 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 nah. But the doctor has to do that to her, right? So again, right, that's a law that is designed to shame and punish women. In this category of laws designed to shame and punish women, I put this race and sex selection abortion ban, Arizona's. This is the Susan B. Anthony and Frederick Douglass Prenatal Non-Discrimination Act.
Yes, they did.
The second bullet shows you the legislative purpose. This is part of the text of the statute. What it does is it makes it a crime for the doctor to perform an abortion if the doctor knows that the reason that the woman is seeking the abortion has to do with the sex or race of the child. And it requires some level of scrutiny, right? So the doctor has to complete an affidavit that becomes permanent part of the woman's medical record that states that I have no knowledge that Jane Smith, who came in today, is seeking this abortion because of the race or sex of her fetus. Arizona is the only place with a race selection abortion ban. There are other states with just sex selection abortion bans that also require varying levels of scrutiny. But so why do I consider this and a law about shaming and punishing women, not so much about access? Well, like many other, facially neutral laws, if we look at the legislative history of this law, we see its discriminatory intent, right? This is just sort of standard Arlington Heights. Think about, say, a poll tax, right? A poll tax on its face is racially neutral, facially neutral, applies to everyone. But we know from the legislative history that the purpose was to disenfranchise, right, Black citizens. So this law, if you look at the legislative history, you will see two things. The law was justified for two reasons. One, the proponents said the abortion among African American women is so high that this, and as compared to white women, that this in and of itself, that race selection abortions are happening. The legislators also said that look at India and China, look at the problems they have with sex selective practices there. The legislators did not point to countries like Albania with largely white women that have also this evidence of sex selective practices going on, but just India and China, and said, look, those people are coming to our country. They're going to bring their ways with them. And if we don't ban this now, the next India or China. So let me give you just some examples. So these are all direct quotes from the legislative history, right? And you can see how, at the beginning, it's like you give them a little credit for trying to sort of, on the surface, maybe trying to co-opt the language of sort of non-discrimination, right? African American babies are, aborted at 5 times the rate of white babies. They're being killed because they're the wrong race. But obviously, this logic falls apart, right? Because the rate of abortion is determined by the number of women who choose abortions. So if you are arguing that the rate of abortion is evidence of race selection abortion, then you are arguing that Black women are perpetuating race selection. And I think you can really see that with this next quote right? So if you say, if I was better at PowerPoint, I would have like done this in a magical way. But say where it says legal abortion, right? Since 1973, say you substitute Black women who decide to have abortions have killed more African Americans than heart disease, cancer, stroke, accidents, AIDS, diabetes, and violent crime, right? African American abortion, have been devastating to the Black community. This was the legislative history. This was the purpose, the justification that was given for this law. And then when we look to the sex selective aspect, right? So here are some examples. And if I had more time, I sometimes compare the language here that was used about Asian women to some of the language from much older cases in the late 19th century, early 20th century, far before Korematsu, but certainly leading up to Korematsu. And the similarities are striking, right? This straight up yellow peril, they are coming, we had a wonderful amicus brief by Asian American Justice Organization explaining this notion of the Asian as the perpetual foreigner, inability to assimilate, right, with these like dangerous customs, we have to sort of isolate. So this is the history looked like for the sex selective. So in light of this legislative history, we went about this the way you would any other racial profiling case, right? So we represent membership organizations whose members include Black and Asian American or Asian Pacific Islander women of childbearing age who have had and will have abortions, right? And alleged that the purpose of the law was to target these women, right? The purpose of the law is to monitor them and to subject their decisions to increase. Even though, like a poll tax, right, it happens to everyone has to pay the tax. The purpose was really to monitor them. But that leads still to sort of an underlying question, which I'm sure is sort of in all of your minds. But what does this law actually do? Right? We know what they wanted it to do, but what does it actually do? Does it stop anybody from getting an abortion? Or is it, and this was actually the phrase that the state of Arizona used to defend it, is it a solution in search of a problem? And if so, does that mean we can't challenge it? Well, and to explain that, right, the legislature passed the law, but it's the Attorney General's office that is stuck defending it. So that was their twist on it. I'm sure the legislators don't believe that. But so they argued, like, look, you haven't shown you haven't been denied an abortion. You haven't asserted that you want a race and sex selection abortion that now you cannot have. And you can't suffer injury because even if you did seek and obtain a race and sex selection abortion, you can't be prosecuted only the doctor can be prosecuted. And so the case that the state really relied upon here is Allen v. Wright. This is a case where the nationwide class of over 1 million Black parents of children sued the IRS, alleging that the IRS wasn't enforcing laws that were supposed to withhold tax benefits from racially discriminatory schools. Now, none of the plaintiffs were saying that their kids were denied entry into these racially discriminated schools. The injury was that the federal government was not doing a good job. It was like essentially the injury was, right, that our government was tolerating these existence and benefiting these racially discriminatory schools. The Supreme Court held there was, and this is sort of the money language that the state of Arizona has relied on the most, right? They said, yes, stigma is sufficient in some circumstances to support standing, but only to those persons who are personally denied equal treatment by the challenged discriminatory conduct. So the state has taken this to mean that that sentence that comes before it is meaningless, right? Because if the state has taken it, stigmatization is never sufficient to support standing. You always show that you were denied access to benefit or privilege or prevented from exercising some sort of right. But this is not only should be wrong, it is wrong, right? That is not actually what this says, and that is not how the case law has developed. So I'm going to give some examples. Start with a local one. There was a case in Cleveland Heights. It was about a racial steering policy that, limited, affected who could live in what neighborhood. And the person who did it was someone who was not forced to leave his neighborhood, right? So he was not affected. The law did not do anything to him, right? But the court said, no, that does not at all insulate it from challenge, right? The city has passed this policy, has enacted something that basically says that, African Americans are so undesirable that they should only live in certain numbers in certain areas. And that harms everyone, right? That harms not only just the people who aren't allowed to live in neighborhoods, but it harms the Black citizen that must live on a daily basis with a sense of disrespect officially established as law. There's another case, a more recent one that really could almost be a very close analogy to ours. The San Francisco City Council passed a resolution. Basically, the Archdiocese had said, we're not going to place children for adoption with gay families because it's bad. And so the San Francisco Council passed a resolution saying, we think what you just said is very bad, right? Like, we think that's horrible and that's hateful, and you, Bishop, whoever, should withdraw that statement. And so a Catholic group and some devout Catholics sued and said that violates the establishment. That violates our rights, because you are essentially passing a law that says we are because of our faith. And the Ninth Circuit agreed that they had standing, right? They said it would be outrageous. The government of San Francisco could condemn the religion of its Catholic citizens, and those citizens could not defend themselves in court. You could so easily see how this applies to our case, right? It would be ridiculous if the state of Arizona could pass a law, the entire purpose of which is to condemn the reproductive decisions of women of color, and then they could not go to court to challenge it because they haven't been injured. So in the interest of time, I'll skip over it, but also in the LGBT context, we also see this notion of stigma. So in closing, right, I like it because kind of the situation here, you can't see the name of the case. It's a very old case from 1939, right? This law is really stupid, right? And a lot of people, when it was passed, was like, yes, no, we know it's really offensive, it's really horrible, it's stupid, but it's just stupid, right? You can't do anything. But, it may be a solution in search of a problem, but who is the face of the problem here, right? How is this any different than, when this was, say, Willie Horton, right? Using the image of the Black man to advance a conservative agenda that was, tough on crime. And so what face are we going to put on that? Well, it's, the evil Black man. Or the welfare queen, right? We want to advance a conservative agenda to, limit benefits. What face are we going to put to that? Well, we're going to put a Black woman, right? So the people behind this want to ban abortion, want to restrict abortion. What are they going to do that, to try to further that movement? Well, they're going to put the face of a Black woman and an Asian on it, right, to make it seem ugly. And so we think, and I just want to, as I said at the beginning, just to bring it back, sort of encourage us as lawyers and as legal scholars to think of harm in a different way when we're talking, or not in a different way, but in an expanded way when we're talking about things like abortion, because it's not always just about the access. Thank you.
All right, I'd like to thank all our panelists. I do want to say 1 minute of wrap up, and then we're going to move to questions. If you have a question, you can go ahead and raise your hand, so this will allow time for the mics to come find you. So wonderful panel. My work is in health disparities, and I think that it really talks about this as well, is that when we think about reproductive justice, reproductive rights, we often work that is removed from health, from greater health, from decisions, from power to make choices. And I think that is a problem as well, that we see the intersection between poverty and your rights to reproduce, but also your rights to have a healthy life, to have health reproductive choices. So I want to thank our panel, and I want to open it up to questions. And I think our first question is from Professor Hill.
Thank you. Yes, I thought that was fantastic and really fit together. The presentations fit together very well. And I guess, Alexa, one of the thoughts I had, and I was glad to hear you talk about it in exactly this. Oh, this really seems like a lawsuit that is aimed at bringing a reproductive justice framework into, the traditional way that we litigate cases. And of course, as you acknowledged, you're facing challenges on the getting courts to understand harm. And I guess that is sort of a theme, right? Is that of the prior panel too, is that these are bigger, broader, systemic, societal problems that the legal system kind of needs to force into individual problems, consent-based, autonomous choices, all of these kinds of individualized categories that just don't fit well with this broader structural understanding. So I guess the question either for you or maybe for other panelists is whether there are other ways or other applications, I guess, you can see for bringing a reproductive justice to the narrower way in which legal disputes, constitutional disputes, have to get litigated in terms of showing standing, having a plaintiff, a specific cause of action. You can, so I'll stop there. But
No, I mean, I think you've sort of listed all the reasons incredibly hard for litigators, right? I mean, to add to the list you just said also, right, that you have to show an intent requirement, right? That if disproportionate impact, like if we could show that to bring a racial discrimination claim alone, like under the Constitution, that's it. Maternal morbidity, that would be a lawsuit, like right there, right? But you have to this like intent requirement. Really, why this Arizona law was just a gift, right? Because they just went to town, right? Like in there, and you can imagine the demographics of the state of Arizona. There wasn't a lot of like pushback, right? When they just all, went to town on Black women and Asian women. And they said everything we needed them to say. I mean, because they wanted to. But so, I think that is why that's the opening here, right? Because we have such unbelievable evidence of discriminatory intent. It's the greater limitation with any equal protection sort of and privacy as well, where it's like the disproportionate impact like isn't good enough. And I don't know if someone knows a good way to change that and to expand that would be great, but
I just want to add, I think there's an opportunity in any sort of litigation to fit our framework. And I'm thinking specifically about Windsor v. U.S., right? U.S. v. Windsor. Like, that case could have been on, very narrow, or rather, Kennedy didn't have to mention all the societal effects of, DOMA. Kennedy didn't have to mention the shame and the stigma that flows to same-sex folks who are interested in getting married as well as their children. He didn't have to mention it. He did, right? And so I think there are those opportunities for courts, the Ninth Circuit, any circuit, any court to strike these laws down on the sort of narrow grounds that the jurisprudence requires us to strike pay attention to, but also in that beautiful dicta that I, will get tattooed in the sleeve of my arm to talk about, the things that we're concerned about. The reasons why Black women have abortions at disproportionate rates, right? It's not about irresponsibility, it's about constrained choices. And so I think that those opportunities are present.
Are you gonna say something?
No, go ahead.
Okay, and so I'm not a lawyer, let me just say that again. Okay, but what's really important to how we are able to like really shape this conversation in the reproductive justice field the personal stories, right? So I feel like law, and when you all are like pushing these cases out, and I know that things have to move fast and it has to be, tight and concise and all of those things, I do opportunity for you all to think about who you're bringing in, like what experts, like really being very strategic about the folks that you were putting, on the stand or putting, in front of the podium, whatever that needs to look like, depending on whatever type of court situation you have going on, but being very strategic about who those folks are, and prepping them to like be able to talk about those things, because it's one thing for it to come from the lawyer, right? Because they're expecting for it to come from you. But if you were like hitting them with expert and you're also infusing in, you know, those directly impacted, or those people that can really story, I think that just as a value added to it, could really make an impact and a change.
No.
So I have actually two questions, because I am kind of in an interesting with this panel as an infertile woman, but also as an abortion rights activist. So I don't know if you want me to ask both of them at the same time, or if you want me to ask one. And okay. So the first question I have is in terms of infertility in the minority community. I got this very sort of a couple months ago an interesting pamphlet from the Cleveland Clinic about freezing my eggs, which I found sort of both really obnoxious and not very well put together. First of all, I'm past the age of being able to freeze my eggs, and also I'm infertile, which means I don't have eggs, so thanks for having me on your list. But also, it seemed very aimed at, clearly at white women in my zip code who have money. And so I wondered how many African American women, you know, maybe in East Cleveland were getting this pamphlet. And so how can we sort of broaden the scope of assisted reproductive technologies to minority women? Because I think that it is prohibitive, even for middle class white women, but for how can we broaden the scope of assisted reproductive technologies to women of every color? And then secondly, as an abortion rights activist, what I deal with is the idea of being pro-choice, because as Ricky Solinger said in her book, Beggars and Choosers, the idea of choice is that it lends us this idea of good choices and bad choices. And so while I am unapologetically pro-choice, I don't always like of the terminology of choice. So is there a movement within the reproductive framework or within the pro-choice movement that we can change that somehow to be more pro-abortion rights, so that we are not allowing the other side to pigeonhole us into women who make bad choices?
Well, the sort of infertility, how do we open up reproductive technological choices, middle class and poorer women? That was sort of your question. You know, I think sort of insurance mandates is a way, right? Sure, make insurance companies cover infertility care, at least to a certain extent, right? So we figure out that it doesn't actually cost that much to add infertility care to insurance policies. It's a couple of dollars per person, you know, per month. It really isn't that much, and we do it. So we make a sort of commitment, part of sort of well women care. Yeah, and for women that don't have private insurance, you know, we've got this wonderful thing called the Affordable Care Act to make infertility care really a part of that in a way that it isn't currently, right? So I do think that those distributive justice issues, right, should make these things more available. I think that has a place, yeah, but I think the truth is that ART doesn't work that well. It gives a lot of false hope. It gives a lot of false hope. It ruins lots of relationships, and it costs a lot of money. And so I don't think our energy should be spent there. It makes a lot of doctors and hospitals rich. It does not surprise me that Cleveland Clinic sent that to you. They don't even take, you know, I mean, Cleveland Clinic, they don't do lots of indigent care anyway. So yeah, they're not sending the pamphlet to Cleveland. They're really pretty and they're glossy, and the clinic is making a lot of money. It's $1 million industry, right? Where 65% of the women that engage in it walk out without baby. Some, you know, it's maybe, you know, healthcare problems too, right? There's some indicators that there might be some connection between the use of those drugs and cancer. So yeah, so that's sort of what I think about sort of infertility, and with the reproductive justice question, how do we, part of, you know, I think of reproductive justice is about choices, but making those choices sort of substantial, right? Not just saying, right, you get a choice, can do that, but making them, I don't know any other word, but maybe you can speak more to that.
No, I think you're right on point. But to go back to the infertility, the freezing of the eggs question, so there's an article that's about to come out of the New York Times. They actually interviewed me and some other RJ folks about this issue as a woman in particular, so you all just keep a lookout for that, because it was interesting, the angle that they were going on. I don't want to give too much of it away, but I think it's going to be something. I think the conversation is starting. More folks who are like really interested in talking about it.
Sorry, I know I don't have the mic, but I think there needs to be a shift in conversation about motherhood and what it means, and that we don't want mothers to be valued.
Yeah.
And I think we need to talk to our
And we have to stop looking at, motherhood is about reproduction, right? I mean, that's what they want it to look like. But, we reproduce a lot of different things. And I think that we reproduce ideas. We reproduce, thoughts. We reproduce expertise. We reproduce a lot. And so I think that just, it's right? And like and that's not to take anything away from the beauty of being a mother, because that is absolutely, hopefully that is my lifeline at some point. But, I reproduce and not just babies, right? And so I just think that it's interesting to kind of like to think about that, and that kind of goes into what I was going to say around like the labeling and the how you choose to identify, because it's your right to self-identify in the ways that fits with you. But what we've been really talking about in the RJ world too, some people are moving away from calling themselves pro-choice, and they're calling themselves a reproductive justice activist, calling themselves a reproductive health or rights activist, right? And moving away from which that, we talked about earlier is kind of like not really taking in full account of like all communities. But what is also really interesting to think about is I really like the term pro-life. I do. I don't like what pro-lifers have done with the term pro-life, right? Because I don't think they're pro-life. I think they're pro-birth, right? And they're about the birth of the whole life of women, girls, people in this country. And so it's like, how do we start to reclaim that language? We were just having this conversation meeting I was at this week. Like, how do we start to reclaim that language from our opposition? Because it really does with us. Like, for those folks who are not just, because also I don't want to say that I'm just about abortion, because I'm also about contraceptive, and I'm also about, mothering and birth justice and all of those things that come along with this whole framework of reproductive justice. So I couldn't say that I'm like pro reproductive health or rights, but I do think that it's time for us to start thinking about how we reclaim language that I feel better suits those of us who really like this more holistic approach to our reproductive health and lives.
All right, so as a moderator, I'm going to allow for 2 more questions. We are past our time, just moving past our time. So we're going to start up here and then go here, and then we're going to hear about lunch.
Professor Cherry, in light of the low IVF success rates that you reported, how would you advise a judge decide a case in which a clinic negligently loses an infertile couple's? And what would the transition from distributive to reproductive justice make the most fitting cause of action a couple might bring? And should a court allow recovery in a case like that?
Yeah, that's interesting, because what's the measure? So what's the damage, right? Where's the harm? If these are so unsuccessful, right, it seems that the measure of damage would be really low if there was any damage at all, because it's easy for the hospital to say, well, it wasn't going to work anyway, right? Right. Right. They're not going to say that, right? Because on the other hand, they've sort of breached their fiduciary duty, right? What I think, right? They breach their fiduciary duty by engaging in this stuff anyway, by pretending it's going to work, or less than they do. But yeah, I think that's sort of I think that's an important question that I don't know the answer to, because there is a harm, right? The harm is the harm of sort of losing the expectation, right?
Even was what you call the false hope.
Yeah, because I think that people that engage, although I sort of understand that people, consent to engaging in this process, given false hope, they're led to believe that their chances, although that the overall statistics might be low, their chances are better, right? And so I do think the loss is that hope that they are led to believe is not false, right? So, but, you know, in terms of litigation, I'm not quite sure how that works because I haven't been a lawyer in a long time or something. But I do think that sort of that's where I would sort of look. Does that make sense?
If it was your last shot,
Right.
as someone who's has not had my embryos lost, and someone who's been through IVF, like if that's your last shot, like
Yeah, because I recognize that there really is that loss.
yeah.
At the same time, I want us to sort of do of motherhood. Like, why is that your last shot, right? Why don't we have mechanisms for, you know, what Patricia Hill Collins calls other mothering and fictive kin, right? That sort of really, you know, what Michelle and I were talking about last night at dinner was aunties, you know? Lord forbid I tell my sisters I'm going to do something to one of my daughters and that they don't have a say, right? That kind of parenting is as important. But that's sort of requiring a social shift, right? Not sort of a legal, changing legal norms.
Okay, let's go to our last question for the panel.
And this question is for Professor Bridges. So you make, I think, an excellent rebuttal of the framework in terms of the privacy discussion. And one of the elements of your rebuttal is the centrality of CPS to the post-birth surveillance framework against privacy. If CPS remains central to your rebuttal prior to birth, or do you also point and identify to other mechanisms for surveillance within that also exist? I mean, not saying that CPS doesn't exist. I mean, you know, girl children also are surveilled as part of that, I imagine, but beyond that.
Absolutely. I didn't have time to talk about that chapter. And the other part of that chapter about the exchange is contextualizing poor women and poor Black women in the communities in which they exist. Mothers are not. So we're talking about communities that are heavily policed. And we're talking about they're heavily to a Fourth Amendment that has been contracted. So poor people only enjoy as much privacy via the police as they do via other private citizens. And that's not any privacy when you're living in a tenement, when you are engaging in all of your sort of activities in public spaces, when you're riding public transportation, when you're depending upon public doctors for your health care. And so their lives are public, whether or not they have children or not. And so that's part of the context which they live. They don't enjoy privacy with children, without children, whether they receive benefits, whether they don't receive benefits. They don't have privacy rights. That's my book.
I'm excited for this book.
Thank you. Yes.
One reflection that tags on to the end of that is a reflection about how much of this is embedded in antebellum slavery in the South.
About it.
People appreciate that slavery is still in the United States so long as you're in prison.
Right.
The amendment carves out that exception.
It does.
Right.
Who bothers to do it? And then look at who's mass incarcerated.
Right.
Yep. That's the same. It ain't never
Right,
ended.
and so with that, I'd like to close. So a beginning of our afternoon talk, Professor Goodwin, who will be talking shortly. So thank you to my panelists.